The Supreme Court ruled recently and unanimously that a Defense Department employee could challenge a 6-day furlough, a furlough that took place in 2013 during a lapse in appropriations. In doing so, the court brushed away a 60-day filing deadline imposed by the Merit Systems Protection Board. It's more complicated than that, though. Joining me in studio to explain it, federal employment attorney Heidi Barakowitz. Heidi, good to have you in.
Thank you. It's wonderful to be here.
And because the Supreme Court heard this case, one is inclined to think, oh my God, this is a big fundamental issue. Not necessarily, though, huh?
Yes, I think the Supreme Court's decision, it was a unanimous decision. It's more of a procedural, technical issue about whether the 60-day deadline for the employee to appeal the MSPB decision to the Federal Circuit is jurisdictional, meaning that it confines what the Federal Circuit can hear, or if it's merely a deadline that's set to ensure the orderly running of the courts and litigation that can be extended for various reasons, such as equitable reasons.
So this person applied to the MSPB to challenge the furlough, but he did so after 60 days, and there was a reason that it took him so long.
Yes, so the employee timely challenged his 6-day furlough back in 2013 when it took place.
Challenged it to?
The MSPB.
Okay.
The administrative judge who heard the case ruled against the employee, and the employee timely appealed that decision to the full board of the MSPB.
Which did not exist at that point, right?
Correct. There was a lack of quorum starting at the beginning, I think, Inauguration Day in 2017 and lasted until 2022. There was a significant backlog of cases because the board could not make any rulings. Well over 3,700 cases backlogged, including this employee was included in there. Tremendously, under Chair Kathy Harris's leadership, since the quorum was restored, has significantly reduced that backlog.
Yeah, they've been doing hundreds a month.
Yes, I think they're down to the latest statistics on the MSPB website is that they're down to 1,073 cases. Unfortunately, this employee's case was held up in the backlog, and during the years that it sat there, his email address changed. So when the board finally issued the decision, the employee did not get notice of it. He had 60 days to appeal directly from the full board to the Federal Circuit Court of Appeals, and he missed that deadline because he didn't find out the decision had been issued until the 60 days had elapsed. The Federal Circuit then said that this was a jurisdictional requirement and they did not have authority to hear his case. He appealed to the Supreme Court. The Supreme Court took the case and determined that this was not a jurisdictional requirement.
Got it. And so, therefore, the appeal will then move forward?
Yes. So the Supreme Court remanded the case back to the Federal Circuit, and the Federal Circuit will have to decide. They have not yet ruled about whether he has a valid excuse for missing the 60 days. That's the first thing that they'll have to determine, and then they can determine the merits of his appeal.
Got it. All right. So then this is a kind of a narrow type of case, but it seems like for anyone that is going to be caught up in deadlines for appealing, there is a possibility that they would have a legitimate reason for missing a deadline, but it's still probably a good idea to try to make the deadline.
Yes, under all circumstances, the best thing to do is to make deadlines. However, in situations like this, the employee missed the deadline through no fault of his own because his email address that he used changed. It was sort of an unprecedented delay at the board in hearing his appeal. And so certainly any employee who does miss a deadline for reasons like that, there is a path forward to have an appeal heard for equitable reasons.
We're speaking with Heidi Barakowitz, a federal employment attorney and partner at Barakowitz and DePriest. I guess maybe the bigger picture is the fact that the monumental furlough over which you had filed class action suits still resonates, even though I think the class action suit failed because court rulings simply said, review for us what happened.
Sure, absolutely. So in 2013, we challenged, this is a little bit different, the employee in the Harrell case challenged his furlough pursuant to sequestration. Our case, our collective action that we filed in the Court of Federal Claims, challenged whether the employees who were deemed essential during the government shutdown that began on October 1st, 2013, could be forced to go to work and not paid on their regularly scheduled payday. We prevailed at the trial court. The judge determined that it was a violation of the FLSA. The Anti-Deficiency Act did not trump the government's statutory obligation under the FLSA to pay employees timely on their regularly scheduled payday. Unfortunately, when the government appealed the case to the federal circuit, we had a 2-1 decision, very close, ruling against us that the government was not liable because of the Anti-Deficiency Act.
Right, for the liquidated damages that you were seeking, because the people had been paid their wages, but you were seeking liquidated damages because of the lateness.
Correct. When it's a violation of the FLSA to not pay an employee on their regularly scheduled pay date, and the remedy for that under the statute is liquidated damages, so the amount of the back pay times 2. So you're correct. The employees had received their back pay, but they were still owed liquidated damages. Unfortunately, the Court of Appeals determined that the government did not violate the Fair Labor Standards Act in this unique circumstance because of the Anti-Deficiency Act, and we appealed to the Supreme Court. It is remarkably difficult to get the Supreme Court to take a case. I think they take less than 2% of the cases that come to them. We had an excellent law professor who was working with us, a Supreme Court expert on the briefs. SCOTUS blog said we were a case to watch, and we were very optimistic, but unfortunately they did not take the case.
So that's where it ends then?
Correct. With a very narrow exception, there are some plaintiffs who still did not get paid on time, although they worked at agencies or components that did have funding. So, for example, in 2013, the Department of Defense employees, shortly, sort of at the last minute before the shutdown started, Congress passed the Pay Our Military Act, in which military personnel and the civilians that support them had funding. For a variety of reasons, however, the Department of Defense did not pay those civilian employees on time. So that is an example of the one issue that remains at the court. Employees who worked for agencies or components that did have funding and still did not get paid on time because, of course, the Anti-Deficiency Act is not a defense.
All right. And, well, while we have you, any other big issues pending in the employment scene for federal employees that you're watching?
Yes, I mean, I think sort of talking about the shutdown or sequestration in 2013, I mean, it's sort of heartbreaking to see the plight of federal employees. You know, we have a big election coming up in November, and certainly I think that the federal workforce should be concerned about who's looking out for them. You know, I do a lot of work for the union that represents the employees at the Federal Bureau of Prisons. They are critically understaffed. I'm constantly afraid that someone is going to be seriously injured or murdered. It's an issue that affects not only the staff, but the inmate safety as well. And it's really necessary that agencies and components like this are getting the funding that they need so that they can operate safely. So that's something, obviously, that I think, you know, all federal employees should be cognizant of. It's an election issue in November.
And then there's the Schedule F question, because former President Trump is one of the people on the ballot, and so presumably without a statutory bar on it, which is cooking but doesn't have that great a chance this Congress, that could be reinstated. Schedule F, which treats certain numbers of federal employees that are career more as if they're political.
Yes, that's another issue that federal employees should be concerned about. Unfortunately, there's a whole host of issues. The fact that the MSPB under the Trump administration had no quorum and that there was this backlog of cases so that employees could not challenge the fact that they were being retaliated against when they were whistleblowers or that they suffered improper personnel actions. That's the legacy of the Trump administration, which, as I mentioned before, under Kathy Harris's leadership at the MSPB, they're trying to rectify. But we certainly don't want to be in that position again after November. So
sounds like you haven't given up the good fight at all yet.
Absolutely not. Absolutely not. And I'm also delighted. I'm celebrating the first anniversary of my new law firm, Barakowitz and DePriest. We've had a great first year. We've collected well over $15 million on behalf of federal workers. We've had some tremendous successes. A case that you were asking sort of what are the issues that we're sort of advocating for. I've had a lot of sexual harassment and rape cases, disability discrimination. We have a lot of pending class actions going on. One case that I feel really strongly about, I represented a woman who was raped at work. The government then...
Yeah, that goes sexual harassment to the extreme.
Absolutely. And it was one of the most, Hollywood could not make up the story about what happened to this woman. It took us 11 and a half years, but we prevailed on her behalf. And the judge awarded her the full $300,000 available to employees under Title VII of the Civil Rights Act of 1964. So we're delighted legislation was just introduced a few weeks ago to lift that statutory cap on damages, because $300,000, it's been in place since the 1990s. It hasn't moved for inflation or any other reason. She's the perfect example of $300,000, against the federal government. It's not enough to get their attention so that they are motivated to eradicate discrimination.